This video will provide a quick review of some key things to know about tort law. In particular, it's the things about tort law that I think it would be most important to know for the bar exam. We'll start here with the core idea that we generally have liability under tort law only when something was your fault. There could be two main ways in which something is your fault. One is an intentional tort, so that requires proof that the defendant acted intentionally. The other type of fault would be negligence, which requires proof that the defendant failed to use reasonable care. There are situations where we have liability without fault or strict liability, but they are the exception. Each of the intentional torts has three basic building blocks. They require an act with a certain kind of intent and a certain kind of result. So, for example, a battery claim requires an act that's done with the intent and result of harmful or offensive contact with the plaintiff. You'll remember that we learned about some states having a single intent approach and some states having a dual intent approach. For the bar exam, where there are different approaches used by different states, you're supposed to apply what is the general majority rule. And so that would be the dual intent approach. That is more common than the single intent approach. Remember that we also learned a bit about what it means for something to be offensive. We saw it has to be offensive to a reasonable person. Notice also that this means a battery can exist where there was no physical harm suffered by the person. An offensive battery, for example, would harm a person emotionally, but not physically. Zeroing in on the intent element, we saw that there are two ways in which you can have the required intent. One is where the defendant had the purpose or desire for something to happen. Like you don't like someone and you want them to be hurt, and so you have the purpose of hurting them. The other is where the defendant doesn't have the purpose or desire to hurt someone, but has knowledge of a substantial certainty that it's going to happen. The elements of assault are similar, but they focus on someone expecting or thinking that a harmful or offensive contact is going to occur. So for assault, you need an act that's done with the intent of putting the plaintiff in apprehension of imminent harmful or offensive contact, and the result is that the plaintiff is put in apprehension of imminent harmful or offensive contact. For these intentional torts and other intentional torts, we looked at the issue of what do you do if the intent doesn't match the result. For example, what if you intended a battery to one person, but the result is a battery to another person? We saw that you'd still have liability. That was the person-to-person kind of transferred intent. Likewise, if you intended one tort, like a battery, and the result was another tort, like assault, you'd also still have liability. That was the tort-to-tort transferred intent. And you're also liable if the result winds up being much more severe than you intended or would have expected. For example, if you intend a relatively mild or minor battery, but the result is extremely worse than you expected, you'd still have liability. This was the extended liability concept that we saw earlier. False imprisonment involves an act that has the intent of confining someone within a limited area, and the result is that they are confined within a limited area, and they're either aware of or harmed by the confinement. We studied a bit about what it means to be confined and what would constitute a limited area. We also saw some particular applications of these elements, such as a situation that would involve duress of goods, where you would be free to leave, but because your property is there, you feel like if you leave, you're likely to lose that property. That can amount to a false imprisonment. We then looked at some intentional torts relating to property. There was trespass to land, where you do an act with the intent of someone or something entering or remaining on land, and the result is that someone or something enters or remains on land that's possessed by the plaintiff. Notice that it can be someone or something, so you can have a trespass by causing a thing to enter someone else's property. We learned about how the trespass could be above ground or below the ground, as well as on the surface of the ground. And probably the really tricky thing to remember about trespass to land was the issue about what sort of intent and requirement are required in terms of who owns the property. We saw that you can be liable even if you made a reasonable mistake about who owns the property. So, for example, if you enter a piece of property, you intend to do so because you think it's yours and you think you're entitled to be there. But it turns out you're mistaken. You can be liable for that. even if your mistake was reasonable and made in good faith. When we looked at property-related torts, we touched just a bit on nuisance claims. So we learned about private nuisance claims, which have to do with interference with your use and enjoyment of your land. Usually be a situation that some neighboring property is doing something that interferes with your ability to enjoy your property. So for example, if there's a farm that's next to a housing development and the farm creates a lot of smells that aren't great for the neighborhood, they might have a private nuisance situation. A public nuisance is broad and somewhat ill-defined. It's when you have an interference with a right that's common to the general public. So, for example, there could be a safety hazard of some kind, like a building that's become a fire hazard. We got into a bit of detail about the distinction between a trespass to land claim and a private nuisance claim. Trespass to land claims require intent. There has to be intent to have entered that piece of property. On the other hand, a private nuisance claim doesn't require any proof of intent. It could be a completely unintentional thing. The key is whether it's interfering with somebody else's use and enjoyment of their property, but it doesn't have to be intentional. We saw that for a trespass to land claim, it generally requires some kind of tangible entry into the property. And on the other hand, private nuisance is broader, and so it could cover things that aren't really tangible, like odors, lights, noises, vibrations. And we saw that trespass to land is more of a mechanical thing, meaning it just has these certain elements to it, and if you satisfy the elements, then there's liability. It's not a matter of degree. It's just a simple matter of did you enter the property or not. And on the other hand, private nuisance is a more flexible thing. It's all about reasonableness and accommodating or balancing everyone's interest in the property. Gives courts more discretion about how to handle things. We also saw a couple of intentional torts that relate to personal property. There was conversion, which is about someone exercising substantial control over your property. So in other words, they could basically be stealing something from you. And there was trespass to chattel, where someone would interfere with your chattel in some way, cause substantial interference with it. For both of these torts, remember that same issue applies about how you can be liable even if you made a reasonable, honest mistake about who owned the property. So if you pick up an item of property because you think that it's yours, that can be a conversion, even if it was a reasonable mistake. And the same is true for trespass to chattel. If you make a reasonable mistake thinking it's your property and it's really not, you can have liability for that. And the final intentional tort that we focused on was intentional infliction of emotional distress. We saw that this one requires an act that is extreme and outrageous, and it really is supposed to be something that is truly extreme and outrageous. It has to be done with intent to cause severe emotional distress, or it was done recklessly, that it was reckless with respect to causing severe emotional distress to someone. And the result has to be that it causes severe emotional distress. One of the complicating issues here was about whether you could have a claim where someone does something extreme and outrageous to another person. So to what extent can you have liability where there's a third party involved? And we saw that generally you can't have such a claim, but there are some exceptions that courts or the restatement recognize. For example, if someone is present and an immediate family member has something extreme and outrageous done to them. But those exceptions are not real consistent from state to state, and even within particular states, it may not be clear what those exceptions would be. After learning about the elements of intentional torts, we turned to defenses for intentional torts. We saw that you might say that you acted out of reasonable self-defense, or reasonable defense of others, reasonable defense of property, or because you were taking actions to stop a suspected criminal, so you were arresting and detaining a suspected criminal. For all these, the key word is reasonable. You need to act in a reasonable way with respect to your belief that acting in defense of yourself or others was necessary, and you must act reasonably in terms of the degree of force that you use or what you do to protect yourself or others or property. But the reasonableness requirement does mean that you can be mistaken. You might think that you're being attacked, and you're really not. And if it was a reasonable belief, you would still be protected by the defense. We also learned about consent and how it could be actual consent or apparent consent. So again, if you reasonably think that you have consent but you're mistaken about it, you still may be able to rely on this defense. We learned about issues about incapacity, how sometimes the consent may be invalid if the defendant knew or should have known that the plaintiff's ability to consent was substantially impaired. And we had the case about that, for example, the Slominski case, about the difficulty of some of those issues. We also looked at the issue of what if the consent was given, but it was based on some kind of a mistake, some kind of a misimpression or misunderstanding. And we saw that basically you're not supposed to lie to people or take advantage of them. So if you deceive them or mislead them to get their consent, then the consent's not valid. And if you knew they were making a mistake or reasonably should have known they were making a mistake, the consent is also not valid. You shouldn't take advantage of them. And on the other hand, if someone mistakenly gives consent, but it's not your fault because you didn't lie to the person about anything, you didn't deceive them, you didn't take advantage of them when you should have known they were making a mistake, then that's not your fault and the consent will still be valid despite the mistake. Necessity can also be a defense, and we saw you might have a situation where there's a public necessity. You're acting to save not just yourself or people close to you, but a whole community, a whole neighborhood, for example. And when that's the case, you can take or use someone else's property and you don't have to pay anything for it. You can damage or destroy their property and you're not liable for anything. On the other hand, in private necessity situations where you're not acting for the whole community, but instead for yourself or maybe your family or friends, it's a more limited defense. You can take or use someone else's property and you won't be liable merely for the use of their property, but to the extent you cause harm to it, then you should pay for that. We then turned to negligence claims. We saw that negligence is all about what a reasonable person would do with respect to risks that are foreseeable. So we begin with the duty element of a negligence claim, and we saw how you generally have a duty to exercise the care of a reasonable person under the circumstances. We also learned quite a bit about how you handle the reasonable person part of the standard of care for negligence. It was an extensive issue that we looked at about to what extent do you just ignore the particular characteristics of the person, you just approach it in an objective way where you say, look, you have a duty just to act like an average reasonable person who is ordinary, or do we customize or modify the standard of care so that you're compared to a reasonable person who has the same characteristics that you have? And we saw there are some things that are taken into account in the standard of care. One was physical problems or physical advantages. So you're expected to act with the care of a reasonable person who has the same physical abilities or limitations that you have. We saw the same thing was true for mental advantages. So if you have extra unusual intelligence or experience or knowledge, then you're expected to act with the care of a reasonable person who has those things. So, for example, if you're highly trained, like you're a doctor, you're expected to act with the care of a reasonable doctor, not just a reasonable person with average knowledge. We saw that the age of children is also taken into account. So a person who is a child has a duty to exercise the care of a reasonable child of the same age in intelligence and experience and maturity and so on. And we saw that involuntary intoxication is also taken into account. So to the extent that someone slipped a drug to you that you weren't aware that you were going to be consuming and that impaired your abilities, you would be expected to act with the care of a reasonable person who had been involuntarily intoxicated in that way. On the other hand, we learned about just a couple of things that are not taken into account: mental problems and voluntary intoxication. So if you have a mental problem, you are still expected to act with the care of a reasonable person of ordinary mental ability. You don't get a break on account of having a mental problem. And the same for voluntary intoxication. If you decide to consume alcohol, for example, you're not expected to just act with the care of a reasonable person who's intoxicated. We set that aside and say you have a duty to exercise the care of a reasonable person, just an average person, not an intoxicated one. We also saw that there were a lot of complicated issues about the extent to which you have a duty to act to help the plaintiff or to protect the plaintiff from others. As a general matter, we saw you have a duty to exercise the care of a reasonable person under the circumstances. You generally don't have a duty to act to help the plaintiff, so if it's merely nonfeasance, you won't be liable. And you generally don't have to protect the plaintiff from other people. But then we saw there are exceptions to these things. So, for example, if you put the plaintiff in danger, you created the risk to the plaintiff, then you may have a duty. You could voluntarily assume a duty that you wouldn't otherwise have. So, for example, if you try to help the plaintiff, then you have to exercise reasonable care in doing so. You could have a duty if you interfered with others who were trying to help the plaintiff, or if there's a law like a statute that specifically requires you to act. You wouldn't have a duty otherwise under the common law, but a statute could give you such a duty. And we saw you might have a duty because you have a special relationship with someone who is involved. And it could either be a special relationship that you have that obligates you to protect the plaintiff, such as if you're a parent and the plaintiff was your child, you have to help your child. It also could be a situation where you have a special relationship with the person who is causing the harm, and you have some duty to control or to restrain that person. So some examples of things that could be special relationships: a common carrier and a passenger, so that would be like a bus or train and the passengers, an innkeeper and a guest, a landlord and a tenant, a business property owner and a lawful entrant on the property. We saw some cases about how that's a little more complicated, and courts might require something in addition to just the existence of the special relationship. They might require some proof about the foreseeability of the crime occurring, maybe previous similar incidents that had occurred. A school and a student can be a special relationship, employer-employee, a custodian and ward, which might again include things like a parent and child, or maybe a prison and an inmate, and then a mental health professional and a patient. So that would be like the Tarasov case that we saw, for example. There were a few other special rules about duty that we covered. One was the firefighter's rule or professional rescuer's doctrine, which says you generally don't have a duty to firefighters or police officers. So that means you won't be liable for injuries they suffer because of your negligence, creating an emergency situation that requires the need for their services. So the example of this would be like if you negligently start a fire and the fire department has to come to deal with the fire. If one of the firefighters gets injured, you won't have liability to the firefighter. You don't have a duty to protect that firefighter from harm in dealing with the emergency situation that you created. We saw that there are some exceptions to this rule and that they varied from state to state. We also learned about a detailed set of rules that cover liability for injuries that occur on someone else's land. So in other words, as someone who owns land, or more specifically someone who possesses land, you have a duty in some circumstances to people who enter the property and then get injured. And it depends on the status or type of person who enters the property. If the person is an invitee, then that's where you have the most duty. An invitee would be someone who's invited to enter the property for your financial benefit, or because it's a place that you've held open to the public. So if somebody's an invitee, then you have a duty to use reasonable care to protect them from harm. And that includes protecting them or warning them about dangers on the property that you either know about or you reasonably should know about. On the other hand, the duty is less for a licensee. A licensee is someone who has permission to enter your property, but it's not for a business purpose or potential financial benefit, and it's not being held open to the public. So this would include like a social guest. If someone's a licensee, you have a duty to them, but it's only a duty to protect them or warn them about known dangers. And then finally, a trespasser is someone who does not have permission to be on the property, and the general common law rules that you don't have a duty to such a person. You don't owe a duty to a trespasser. But we saw there are some exceptions to that, and again, they're complicated and they vary to some extent from state to state. In addition, we saw that some states have done away with some or all of these categories. They've shifted away from using all of these categories, or at least perhaps eliminating the distinction between invitees and licensees. So if there's a question about this on the bar exam or on a test in this course, the question might signal to you whether these categories are still being used. For example, the question might say that the state has preserved the traditional rules about the liability of landowners. As I mentioned, there are a number of exceptions that apply to the general rule that you don't have a duty to trespassers. One of them that you might remember is the phrase attractive nuisance. And so this would be an example of one of the exceptions. It's an artificial dangerous condition on your land that would draw children there, and the children wouldn't understand the danger, and so this is something that where you might have a duty, despite the general notion that you don't have a duty to trespassers. The second element of a negligence claim is breach. Remember that duty is an issue of law, but breach and the other elements are issues of fact. And there are a couple different ways you could show that there was a breach of the duty to exercise reasonable care. The simplest ordinary way is you simply present evidence. You try to convince the trier of fact, which would normally be a jury, that the person failed to exercise reasonable care. You might try to use the learned hand formula to do that. That approach takes into account the probability that harm is going to occur, the potential severity of that harm, and the burden or cost of alternative ways of trying to make the situation safer. A second way you could try to prove breach is by using the shortcut of negligence per se. You argue that the person broke the law, they violated a statute or ordinance or regulation, and that is negligent per se, meaning it's automatically negligent. The jury doesn't have to evaluate the reasonableness of the conduct, it's just automatically negligent per se to violate the law. But it's not that much of a shortcut because you do have to show some requirements are met. For example, you have to show that the plaintiff was within the class of people the legislature was trying to protect when they passed this law. And you have to show that the injury was the sort of thing the legislature was trying to address when they enacted the law. And in addition, the defendant might try to show that he had a valid excuse for violating the law. The third way you could try to prove breach is with res ipsa loquitur. So here you'd be using circumstantial evidence. You don't really know what the negligence is, but you feel like the situation makes it probable that there was negligence and that it was negligence by the defendant. And so the jury then would have the option of inferring that there was negligence, even if you can't specify what happened that was the negligent thing. The third element of a negligence claim is actual cause, and for this you have the but-for test. You ask if the plaintiff's injury would have occurred but for the negligence. But for the negligence, would the plaintiff have been okay and the injury would have been prevented? If so, then the negligence made a difference, it changed the outcome, so it is an actual cause. And if it didn't make any difference, then it wasn't an actual cause. That's the main rule that covers actual causation most of the time, but we saw there are a couple special rules for special situations. One was duplicative causation or multiple sufficient causes. This is like the Anderson case we saw where the two fires come. There's more than one fire, each one is sufficient to cause the harm. Therefore, neither one of them was a necessary, critical ingredient in what occurred, but for each of the fires, there still would have been other fires that would have caused the harm. So it wouldn't be an actual cause under the but-for test, but we go ahead and treat it as an actual cause anyway. It's just that there were multiple things that were redundant, but each of them was sufficient to cause the harm. So in situations like that where the two fires come together, that is treated as an actual cause. Preemptive cause is where something happens too late. One thing has already caused the harm, it's over and done and complete, and then something else happens that also would have been sufficient to cause the harm, but it's too late because the harm already occurred. The second force can't be the cause of the harm because it's preempted by what already happened and completed the harm. Another special rule under actual cause would be alternative liability. This is like the situation with the two hunters in the Summers versus Tice case. So here you have a group of people. You have to prove that they were all negligent. They all did the tortious thing. One of them caused the harm to the plaintiff, but we're not sure which. And so if you sue them all, the burden of proof about actual causation can be shifted to the defendants. Each one has to try to prove that they were not the one who actually caused the harm to the plaintiff. And we also saw the doctrine of last clear chance, which is another special rule within actual causation. It is for the context of medical malpractice, situations where a doctor acted negligently, but we can't really say that it probably caused harm to the plaintiff, because the plaintiff's chances of a good result, such as surviving an illness, were low anyway. They were below the 50% threshold that we would need to be able to have actual cause proven by a preponderance of the evidence. And so the lost chance doctrine enables us to get around that problem. We recharacterize the harm that you suffered as being the chance that you lost, the chance to be able to get good medical treatment and hope for a good outcome. Having recharacterized the harm as being your lost chance, we then have to be sure that we value that lost chance correctly, and we do that by using the percentages, and rather than awarding you the full damages for the harm that you suffered, we give you a portion of it based on the chances that the doctor's negligence in fact did cause you to lose a chance for a better result. So for example, if there was only a 10% chance that you were going to survive if the doctor had given you proper treatment, we'll allow you to recover 10% of the damages you would otherwise get. The fourth element of a negligence claim is proximate cause. This is an element that's hard to apply, hard to pin down, hard to figure out exactly what it should require. But it basically has a lot to do with foreseeability. Was the plaintiff's injury a foreseeable result of the defendant's conduct? Was the plaintiff the kind of person we'd foresee getting injured? And was the harm that the plaintiff suffered the kind of harm that we would reasonably foresee occurring as a result of this negligence? We saw there are some special rules. Some things are treated as being foreseeable, even if they may not really have been foreseeable. The rescue doctrine means that rescuers are treated as being foreseeable. And we also treat subsequent medical malpractice, subsequent diseases, and subsequent accidents as being foreseeable, even if in fact they really were not. Just like we saw there are defenses to intentional tort claims, there are also defenses for negligence claims. One of the traditional defenses for negligence claims was express assumption of risk. This would be where the plaintiff had agreed to waive liability. And that's still a defense. If you agree to waive liability, and if we decide that it covers the situation and the injury that you suffered, and there's no particular public policy reason why we should refuse to enforce that waiver, then you have waived liability. You agreed not to sue about something, and we'll hold you to that. The other traditional defenses were implied assumption of risk and contributory negligence, and these are things that have changed over time. And it's a little bit complicated, but we studied this in some detail. We saw that most states, 46 of them, have now shifted over, and they don't have the old all-or-nothing contributory negligence defense anymore. Instead, they have some type of comparative fault, whether it's the pure kind or the modified kind. And we saw that there's been some change in thinking about implied assumption of risk as well. Courts used to draw distinctions between different kinds of implied assumption of risk, and they were all defenses, but there would be the primary type and the secondary type. And more recent decisions, like the Missouri decision we read, the Coomer case about the Kansas City Royals mascot, we saw that they really clarified this area quite a bit. They've made it clear that primary implied assumption of risk is really just another way of saying that the defendant didn't have a duty to eliminate the danger in question because it was just an inherent part of the activity. And they've explained that secondary implied assumption of risk is really just another type of fault by the plaintiff. And so it really can just be taken into account in the comparative fault analysis, and we don't need a separate special rule for it anymore. Once you've gone through all the elements of the negligence claims and you've considered whether there are any defenses, if you decide that there is liability, it's possible there may be liability by more than one defendant. If two or more defendants have caused injuries, the first thing you want to do is try to do a causal apportionment. If you can allocate it by who caused what and say, oh, this person injured my foot and this other person injured my head, then you can allocate it that way. But if instead you have an indivisible injury where you can't allocate it by who caused what, then you need another way to do it. Another way to deal with the fact that you have multiple defendants who are liable. The traditional way to handle this was through joint and several liability. You would say both defendants or all the defendants were jointly and severally liable, and so the plaintiff can recover the entire amount of the damages from any one or any combination of them. You can't recover more than the amount of your harm, and you can't recover more than the amount of your damages, but you can get the money from any defendant who has it, anybody you want to go after. And then there may be contribution claims brought among the defendants to reallocate the liability after the plaintiff has been paid. For purposes of the bar exam, you are supposed to assume that joint and several liability applies, unless the question tells you otherwise. You are to assume there's pure comparative fault and there's joint and several liability, unless the question tells you otherwise. Finally, there is respondeat superior, which is a very important doctrine within torts. This is the idea of an employer being held liable for the tort of an employee. If an employee does a tort, such as negligence, within the scope of employment, then the employer can be held liable for it. So even if the employer didn't really directly do anything wrong, the employer can be held liable for the negligence of the employee, if it is within the scope of employment. So hopefully this has been a helpful recap of some of the major things you want to know about negligence and intentional tort claims for purposes of being ready for the bar exam, as well as ready for practicing such questions in this course.